Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Lope TV. If you haven't already, please go ahead and hit that like button, hit that subscription button, and turn that notification bell on. I'll give y'all a few seconds to do that. All right, so this is essentially the second installment of all 50 states holding the people are sovereign. So what I'm going to be doing again is I'm not going to be reading the whole entire cases of every case that I cite because I simply do not have time for that. But I will provide y'all with the case citation for you to go and read on your own. Give me 1 second, y'all. I'll be right back. All right, everybody, I am back. Now I want to reiterate something that I've already said in a lot of my videos. If you really want to know what is going on, you're going to have to read old cases, because the cases today, the so-called judiciary, they have been compromised. All right. So you have to go back in time and read the old cases, because I truly believe back then the judiciary really did their job back then. So always do your best to go and read old cases. If you can't find the cases, just go on case.law. And every case that you need from, if it was ever filed in your so-called state, is going to be on there. But anyway, let's just jump right on into this. So the case of Wells versus Bain, this is a Pennsylvania, well, this case citation is a Pennsylvania's case, but this is an Alabama, if I'm not mistaken, Supreme Court case that is actually citing the case. Let me go and look at the case citation just to be sure. Yeah. So this is an Alabama Supreme Court case that is citing it. All right. So it says, in the case of Wells versus Bain, also cited by this court in City of Bessemer versus Birmingham Electric Company, involved the question of what method of the constitutional change was available as an alternative to the legislature's proposal of an amendment, construing a declaration of rights that is similar to that contained in our present Constitution insofar as it concerns the inalienable rights of the people to change their form of government in such manner as they wish. The Supreme Court of Pennsylvania said, now at this time, right here in 1874, the Pennsylvania, according to this case, the Pennsylvania Constitution had no provision for calling a constitutional convention. All right. This is what the Supreme Court of Pennsylvania at this time, 1874, held. It said, the words, in such manner as they may think proper, that is extremely broad, in the Declaration of Rights, embrace but three known recognized modes by which the whole people, the state, can give their consent to an alteration of an existing lawful frame of government, viz., so here's the three right here. 1, the mode provided in the existing Constitution, or in other words, in a manner that they have prescribed to themselves in their Constitution. 2, a law as the instrumental process of raising the body for revision and conveying it to the powers of the people. I don't think I would do that if that means what I think it. If that means what I think it means. When they say the body, they're talking about the legislative body, if I'm not mistaken, and I wouldn't do that. Or 3, a revolution. Those are the only 3 ways at this particular time in which that they could, the sovereign people of Pennsylvania could, change their constitution. The first 2 are peaceful means through which the consent of the people to alteration is obtained. Notice that they need your permission. They need your agreement. They need your assent. They need your consent. They need your authorization. They need your approval. The first 2 are peaceful means through which the consent of the people to alteration is obtained, and by which the existing government consents to be displaced without revolution. The government gives its consent either by pursuing the mode provided in the Constitution or by passing a law to call a convention. If consent be not so given by the existing government. The remedy of the people is the third mode, revolution. This is one of the reasons why I say everything the people did on January, was it January the 6th, 2020, or whatever, when they say they raided the Capitol or whatever you want to call it. Like, this is their government. You can't, what else you supposed to do? If you reasonably suspect that your public servants are tyrants and they don't want to leave public, like you're trying to do this peacefully and to avoid as much as possible bloodshed and loss of life as you possibly can, and they refuse to do that, what are you supposed to do? You can't sleep on your rights. So let's go to the next one. Connecticut. So this is essentially, this is a new video. So we're gonna do different states. Connecticut. The Connecticut Constitution may be amended in one of the two ways. First, any legislature may propose an amendment. See Connecticut Constitution Amendment, was that Article 6? Yeah, Amendment 6, I'm sorry. The proposed amendment must be approved either by 3/4 of the members of each house of the General Assembly or by at least a majority of the members of each house in 2 successive sessions, yada, yada, yada. Let's go on down here. Once so adopted, the amendment is presented to the people for their approval at the next general election, for their consent, for their assent, for their approval, for their authorization, for their sanction. To be effective, it must receive the support of the majority, yada, yada, yada. Here's the second one right here. This is the part that I want to focus on right here. Second, because they said it can only be amended in 2 ways. Now, y'all keep in mind that some of this stuff may have changed, but I'm trying to get y'all to focus on the people are sovereign. All these so-called public servants or magistrates, all right? They public servants and magistrates, they're trustees, all right? Second, the Constitution may be amended at a convention called for such purposes. A constitutional convention can be called by either the General Assembly or the people. So if you're in Connecticut, you might want to research this stuff to see if this is still, I think this is still valid, because I think this is from like 2006 or 2016 or something like that. Let's go down some more. The preservation of judicial constitutional error may result in cost beyond those arising from the difficulty of correcting such an error. Such cost result when a judicial decision alters or disturbs the state polity. A brief digression into our constitutional history and theory is needed to better understand this harm. A fundamental principle of American government and constitutions, including the constitutions of the many states, is popular sovereignty. Where are we at? In essence, popular sovereignty is the theory that in a free society, the people hold the power and the government has only the power the people delegated it, granted it, authorized it to do, so on and so forth like that. Explaining founding era understanding of Republican government. Let's go down a little bit more. Delegation of powers occurs through the adoption of a constitution, which establishes the government and delegate the powers among the branches. Through this delegation, the people may reserve certain rights to themselves, limiting the government's power to act in particular areas. Also central to popular sovereignty is the people's ability to alter or abolish the established government, a right they exclusively hold. That means nobody else holds this right. It belongs exclusively to the people. It doesn't belong to the judiciary, it doesn't belong to the legislature, and it doesn't belong to the executive. That is, only the people and not the governmental institutions they have ordained can alter the structure and powers of government. The colonial citizens of Connecticut were no strangers to the ideals embodied in popular sovereignty. In fact, evidence dating back to the 1630s. Look at this. This is how old this is. To the 1630s demonstrates that the populace of the Connecticut colony adopted popular sovereignty principles. Let's see. In a 1638 sermon, Puritan Reverend Thomas Hooker expounded on these principles. Specifically, Reverend Hooker stressed that the civil power resided with the people. The people had the authority to elect their political leaders, and the people established the limits within which their political leaders could act. This sermon, it is argued by many, was the catalyst of the Fundamental Orders of 1639. Let's see. The Fundamental Orders contain the germs of a great principle, the principle of self-government based on a limited measure of popular control. This form of government and the popular sovereignty principles on which it was founded continued under the Charter of 1662 after Connecticut's signing of the Declaration of Independence in 1776, and are embodied in the 1818 and 1965 state constitutions. Indeed, the principle is explicitly expressed in our Article 1st, Section 2 of the Connecticut Constitution. All political power is inherent in the people, and all free governments are founded on their authority. And this is the case right here. So this is from 2016. So this is more than likely this is still valid, just to let y'all know. And there's the case citation right there. This is another Connecticut case. Article 1st, Section 1 of the Connecticut Constitution, which describes the Constitution as a social compact, provides additional textual support for the conclusion that capital punishment is deemed morally acceptable in Connecticut. Just disregard that, because that's not really what this video is about. This is about what the Constitution is and who's sovereign, and essentially that's what this is about. A social compact is an agreement between the people and the government they create that binds the agencies of government to respect the blueprint of government and the rights retained by the people. The United States Constitution as social compact in the American Philosophical Society. So we're going to go down a little bit more. Social compact theory posits that all individuals are born with certain natural rights, and that people, notice they said natural rights, fundamental rights, not civil rights, and that people, in freely consenting to be governed, enter a social compact with their government by virtue of which they relinquish certain individual liberties in exchange for the mutual preservation of their lives, liberties, and estates. John Locke Treatise, yada, yada, yada. It's from 2016. Okay. This is the case citation right down here if y'all want to read it. Let's go to Delaware. The people, in the exercise of their sovereign power, make the organic or fundamental law, which, as the Constitution of this state, is unalterable except in the mode it prescribes or by revolution. This is in Delaware. They're saying the same thing. This is the case citation right here. This is from 1847. So here's a Florida case. Go down. The people are the ultimate sovereign. Let's see. Recognizing. So this is a case, Florida, 1958. Rivera Cruz versus Gray. Recognizing that the Constitution is the people's document, as said by George Mason in the Virginia Declaration of Rights, adopted June 12, 1776, all powers is vested in and consequently derived from the people. Therefore, magistrates, that means public servants, therefore magistrates are their trustees and servants, and at all times amenable to them. I don't care if this is not in your state constitution. This still applies, because you have to understand what we are operating under. We're operating under principles, and if the principle is the people of every so-called state or within these so-called states are sovereign, then this principle applies. Doesn't matter if it's in Florida or not. There's the case right there, 2006. Let's go to Georgia. The courts, the legislature, state agencies, the press, and the parties in this case are all subject to the sovereign power of the people. Anyway, there's the case right there, Georgia. What I'm posting this just to let you know that the people are sovereign in Georgia. All right, here's another case. I think I might have did 3 in Georgia. Not really sure. All right. Fundamental principles embodied in our Constitution dictate that the people control their government. All government of right originates with the people, is founded upon their will only, and is instituted solely for the good of the whole. Public officers, aka magistrates, aka public servants, are the trustees and servants of the people, and at all times amenable to them. I don't care if this is not in your state constitution. I don't care if no Supreme Court case or no state court case, whatever in your so-called state ever holds this. This still applies because the people are sovereign. Just to let y'all know, the governments, that they're created under the exclusive jurisdiction of common law. The people under the common law brought the government into existence. It is contended that this provision, constitutional convention, means that a completely revised or new constitution can be formulated by a convention, and in no other manner. We are now dealing with a written constitution, the original law by which our system of government was set up. It creates the government. By its provision, the 3 branches of our government, these are all administrative agencies of the people. The legislature is an administrative agency of the people. The executive is an administrative agency of the people. And the judiciary, or the judicial, is an administrative agency of the people. The law that they are administering is the Constitution. It creates the government. By its provisions, the 3 branches of our government, legislative, executive, and judicial, are created. The 3 branches of government must look to it for all their power and authority. Not so with the sovereign power of the people. The people don't have to do that. Under our system of government, all power and authority is vested in the sovereign people, subject only to such limitations as they have expressly, not implicitly, expressly imposed upon themselves by this organic law, the Constitution. With this as the basis from which we reason, it is true that the provision of the Constitution of 1877 limits the power of the sovereign people to a convention as the only means by which they can have a completely revised or new constitution. So he's asking a question. That's what he's saying. He says, with this as the basis from which we reason, is it true that the provision of the Constitution of 1877 limits the power of the sovereign people to a convention as the only means by which they can have a completely revised or new constitution? The language does not say so. What language? The language in the Constitution. The section purports to do nothing more than to place limitations upon the legislative branch of government as to the manner in which a convention can be called by this branch of the government. If we should say that the sovereign people themselves can adopt a new constitution by the convention, let me read that again. If we should say that the sovereign people themselves can adopt a new constitution by the convention method only, we would by implication be writing into the clause of the Constitution a limitation on the sovereign power of the people. Now, you can't do that. We do not hesitate to say that a court is never justified in placing by implication a limitation upon the sovereign. This would be an unauthorized exercise of sovereign power by the court. No, you can't do that. There's the Georgia case, right? This is from 1946. There it is right there. We got Kentucky. I think Kentucky might be the last one. Kentucky. If there be authority for such action, it must be derived from the sovereign power of the people as delineated in Section 4 of the Bill of Rights. All power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, happiness, and protection of property. For the advancement of these ends, they have at all times an inalienable and indefeasible right to alter, reform, or abolish their government in any such manner as they may deem proper. That might be it. Let's see. Yeah, that's it. Okay. So there's a few states that I kind of missed, like the District of Columbia. I couldn't find anything for the District of Columbia. Couldn't really find anything for Hawaii, Guam. These are the Guam. Those are that. If I'm not mistaken, Guam is a territory, and District of Columbia is a territory. So obviously, they're not going to be sovereign. But anyway, um, I'm not finished. All right. So I'll do probably about 3, maybe 4 more videos. I'm going through all so-called of the 50 states, reading this stuff to you. So that will be the end of this video. The Supreme Litigant is out. Peace.